As a general proposition, take 10 deep breaths. I will tell you that the ACA does not make all that many sweeping changes to what we're already doing. In fact, by the nature of it in the interface, the issues are going to be very detailed and precise and probably will take time to figure out. The first one I want to cover is not in your materials. It has to do with the subject of HSAs, FSAs, and HRAs. HSAs are health savings accounts. FSAs are flexible spending accounts. HRAs are health reimbursement arrangements. If you're an employee, have employees, or represent employees, you've seen these accounts already in your practice and should know them. You might ask yourself, what are the differences between the different spending accounts that employees may set up as a result of their health care? HSAs are employee funded. They are owned by the employee. They are portable, which means they can be taken when termination occurs. They cover some prescription expenses, but not all. They can bear interest. FSAs are a related animal to HSAs, but don't cover all the same medical expenses. Usually, as a general proposition, they're involving dental, vision, and other healthcare expenses not covered under an HSA. The difference with the FSA versus the HSA, as you recall, is the FSA was you either use it or you lose it because it would not carry over. The HSA carries over from year to year, and clients can build up a fund of HSA expenses in the account. FSAs traditionally could not. One of the changes with the ACA is that we can now carry over $500 from the FSA from year to year going forward. Now, what I've said so far should not come as any news. We should already be doing in our practices an analysis of our clients' HSA accounts when we're doing a division of community assets, because those contributions that have built up over the last number of years are already a community asset to be divided. So when you're talking about temporary orders and a spouse says, I can't pay for my medical coverage, now I'm separately responsible for what I'm incurring, the thought should be in your head, well, you've already contributed to that by contributing to your HSA during the course of the marriage, and therefore you do have a resource to pay for those separate expenses after the date of service. On a long-term basis, we should be remembering that those HSAs need to be divided as an asset and always be looked at. Same with FSAs going forward, because we will now be able to carry them forward under ACA, which we did not have before. I didn't know what an HRA was until I started preparing for this presentation. You may be more up on it than I am. I'm going to give you a website. It's called shrm.org, the Society for Human Resource Management, if you'd like to know more about HRAs. They were used a lot in the beginning, particularly by companies like Intel and others, for developing reimbursement arrangements. The difference with an HRA is that it's established by the employer, not the employee. It's an incentive for employment, which the employer pays, and therefore the employee will not be required to take their own funds out of their own compensation in order to fund it. That's why it has some advantages. The problem with it is that it's not portable and it's not owned by the employee, so it's not really divisible because there is nothing owned by the community. So just be aware of those issues when it comes to what to do with them, either temporarily, under temporary orders, or permanently. With regard to child support, one of the primary changes under the ACA has to do with the dependency exemption. Under the ACA, the parent who could claim the dependent on their return is responsible for maintaining the coverage for the dependent. Under our current guidelines in Arizona law, it doesn't matter which parent provides the insurance as to which parent gets the dependency exemption. Now, this is not unusual because, remember, Obamacare has decided the IRS is going to run the program. And there are penalties that apply tax-wise for failure to register in the marketplace. So now they've combined the two, so we have to be careful because there is not a solution yet with regard to the dependency exemption under the ACA. I suspect we're going to have one of two solutions. We'll either keep doing what we're presently doing, which is where the federal government winks and nods and says the state law applies and we can do the dependency exemptions under the current guidelines, or the federal government is going to say, no, we take priority, and the states will back out, and we're going to have to start thinking about making sure that the person who provides the insurance coverage is the one who gets the dependency exemptions. But it is unsolved, and we need to be aware that going forward, that's an issue that has to be addressed either by our legislature, by the guidelines, by federal government, or maybe all of the above. That leads us right into the next subject, which is the coverage source, and that is which parent is going to provide the medical insurance for the children. Because that raises the conflict between which parent is going to do it. It also raises a question with regard to coverage gaps. Under the ACA, a coverage gap under 3 months is exempt from the penalties that apply for failing to register. However, the parent not ordered to provide coverage may be at risk if the parent ordered to provide the coverage fails to do so. So this obviously leads to uncertainty. Another provision is the tax penalty that applies. Under the ACA, parents are liable for the shared responsibility payment, or the penalty, for a dependent if the dependent is claimed on a tax return. But if the parent ordered to provide the coverage fails to do so, the other parent may be at risk for having to pay that penalty. As of June 2013, there has been an exception made in hardship cases. I'm not asking you to be an expert on what that all means, but you need to be able to advise your clients that if they're facing an IRS penalty for that particular violation, that they have an option to take to get out of it with their tax preparer. We should be at least informed enough to be able to tell them that. The last aspect of child support or medical support that I would like to cover has to do with access. I had a conversation with Paula Cotita, who's the supervisor of the Southeast facility with regard to 4D cases, because I thought she would have some excellent information. Unfortunately, the state of Arizona hasn't yet asked for an interface between the ACA and our current family law and child support statutes. But she wrote a great article on the Glover case in 2012. You may have seen it and distributed it. She also talked to me about the current policy of access. Right now, Access is paying for health care of those who qualify, particularly children. And until now, there has not been a great move to seek reimbursement from third-party care providers. That is changing. Access is now seeking reimbursement, even to the point of litigation against healthcare providers, where a parent was required to provide the coverage, failed to do so, and Access had to step in and make the payments. What that means is that our clients may or may not be involved in that litigation as it goes forward for reimbursement, so you may see that from time to time in the future. Cobra, how is that impacted by the ACA? Well, not a whole lot. We still have the 3-year rules, and a non-employed spouse has the right to make an election after the divorce as to whether to stay on Cobra or whether to not stay on Cobra. The notices that are sent which provide the election to the non-employed spouse are going to be substantially different than they are today. You may get asked questions about those, but they will have options in there, subsidies, credits, and all the lingo that applies to the ACA. The non-covered spouse will also have the option of whether they continue to take Cobra or whether they don't, just as they do now. They can either stay with the Cobra through the employer, they can seek alternative coverage in the marketplace, which they have the right to do, or they may pay a penalty if they're not exempt. So no longer can we allow our non-employed spouses, when they say, well, I'm just going to let it go for a while, when they don't take Cobra, to do so, because they may suffer the penalty or other legal complications. So they have to be able to get some insurance in one form or another. Note, it may be cheaper for them to just go to the marketplace and stay on Cobra. You may have clients on Cobra today that should be shopping the market instead of staying on Cobra. No pre-existing conditions, gaps in coverage, other things are eliminated by shopping the marketplace. 2 of the healthcare providers that I spoke with and talked to them about what will happen with Cobra, because it became apparent to me that it's going to probably change. And they've both predicted eventually Cobra will probably phase itself out because it will no longer be necessary in the current market environment with the ACA. So as practitioners, we will probably see that diminish over time. I wanted to know what was the impact of ACA on emancipated children. Under the new act, children from 18 to 26 who are emancipated may be kept on their parents' insurance under the ACA, regardless of their circumstances, regardless of marriage, regardless of whether they live with their parents, regardless of whether they go to college, regardless of whether they're alternatively employed, regardless of whether their alternative employment already provides their own health insurance that they could get on their own. They can stay on their parents' plan until age 26. Caveat: you cannot use HSA money of the parents that have been stored through their employer to pay for the non-covered expenses of an adult child. So if they're over 18 to 26, you can't use the HSA money. That means either the child or another source has to be used in order to pay up to the deductible or to the predetermined limits based on their income. Of course, the ACA does not mandate the coverage for an adult child. It's to be agreed upon, just like we do now with other post-emancipation expenses, such as college, LDS missions, weddings, you name it, whatever it is, it still has to be agreed. So that raises an interesting question. Should we be talking about this subject with our clients when we're writing property settlement agreements? Answer: yes. At least they should be given the option of whether they want to agree to those type of arrangements or not. And if a failure on our part to at least give them that choice would not be a good idea. Attached in the materials are the case law sites which talk about post-emancipation expenses in other areas, predominantly schooling. There is one that addresses a medical care expense beyond emancipation. They're only there because they give you the analogous provisions under our current law as we move forward and possibly have non-covered medical expenses in order to address. Okay, thank you. The last little subject that I wanted to address was Medicare. I'm not sure if it's because I continue to age, or my clients continue to age, or the population getting divorced continues to age, but I'm having more and more cases with people over 65 who are on Medicare who are getting divorced. And so they'll come in with Social Security benefits already, Medicare benefits already, so I wanted to know what is the impact I'm going to give to them about the ACA. The answer is nothing negative. The Medicare provisions are a compliance instrument with regard to the current ACA elements. Therefore, they don't have to make any changes whatsoever. In fact, what it actually does is increases their benefits because some of the preventative services that were otherwise not covered by Medicare, such as mammograms, colonoscopies, and other things, are now covered under the new law. So I think the great information that we can provide to our 65-plus clients is you have even more benefits than you had before, and the ACA is not taking anything away. I was also told that the ACA reduces the cost of prescription drugs by gradually closing out the Part D donut hole. Don't ask me what the Part D donut hole is. I have no idea, but it's being closed out as a result of those items. So in conclusion, I'll just say, yes, we face a lot of challenges in this area. We're going to have to stay informed and keep up with it. None of them are too significant that we can't handle at the present time, and hopefully something I've said today, despite Bob's request, will be a benefit to you as you go forward in your practices. Thank you.